Well, first, it puts others on notice that it is your work has been copyrighted or protected. It is required to file suit in a U.S. federal court if it's a work of U.S. origin. So for works of U.S. origin, you can't sue in the federal court system without a registration. The registration certificate will also be prima facie evidence of the validity of the copyright and the facts in the certificate if the copyright certificate is made within 5 years of publication. If you're worried that people will kind of infringe your work overseas and those infringing copies will be imported into the US, if you have registered your work, you can record that registration with CPB and they will prevent the importation of the pirated products. May be available in litigation, but only if the registration is obtained within 3 months after publication of a work or prior to the infringement of the work. And it's often difficult to prove damages, to prove actual damages in copyright cases. So a lot of people rely on statutory damages and attorney's fees, which are only available when you've registered the work. It's also, frankly, you want to monetize your work. It's easier to license, collect royalties, and enforce your rights outside of court if you've got a registration. So registration is administered by the U.S. Copyright Office, part of the Library of Congress. We don't do this at the PTO. We are part of the executive branch. Registration can be made using paper forms or submitted online. It's cheaper online. It's easier. If you go to copyright.gov, they've got all the information. They also have a number of circulars about everything in the world, and the circulars are super, super helpful. So the registration process, you file an application, you pay a filing fee. And just so you see, this filing fee isn't like per work, it's per filing. So for example, you can have, 10 songs on a tape and register all 10 for the same price. You don't have to pay that price for each of them. And you have to deposit copies of the work at the Copyright Office. And some of the works can be selected for collections of the Library of Congress. So as I said, we're not like the PTO. It does not, I am the PTO. The Copyright Office registration is not like a registration at the PTO. It does not involve a complex examination. The time is much quicker, 1 to 3 months for online claims, 4 to 8 months for manual claims. They conduct a simple examination of each work to determine whether the work is copyrightable and the compliance with the legal requirements. A small percentage of applications for registration are refused because they'll say, hey, this isn't copyrightable. This is, a useful article. It can't be protected by copyright. Or this was created by AI. It can't be protected by copyright. So notice is not required for works that were published after '89. I counted because I thought '89 was just a few years ago. So when I was preparing for this, I counted. It was like 30 years ago. So it was a long time ago. The forms of a copyright notice, see with the circle. For sound recordings, people use P with a circle because we used to call them phonorecords. The word copyright, the abbreviation copyright, the year of publication, and the name of the copyright. So here's an example. Copyright 2024, Jane Doe. Good, you should put copyright notices on things. Are they required? No, but they're helpful. You may want to put an email address or something else like that too, because the key thing is you want to get information. So if somebody wants a license, they can come to you and pay you and get a license. So it's great if you have, information that will give them enough information to find you and ask for permission. So why would you use a copyright notice? To inform the public that the work is protected, to identify the copyright owner, show them when the work was first published. And it also, there is something called an innocent infringer defense, and that can bear on remedies. And it's hard to make an innocent infringer defense if there is notice on the work. So for term of copyright, again, different from patent and trademark. Patent is a fairly short term. Trademark can be perpetual if you keep using it and keep filing. Copyright is a fixed term, but it's longer. In the US, it's life plus 70 years. So I write a book, it lasts throughout my life, and when I die, it lasts for 70 more years. It's 95 years from publication if the author is not a natural person, 95 years from publication, or 120 years from creation, whichever expires first. So that's like a movie where the movie studio is considered the author. Their protection will last 95 years for publication, or if they never publish it, 120 years from when they create it. So who owns your copyright? It initially vests in the person who conceives the work and fixes its impression in a tangible medium. That's what we call the author, the person who writes the book. Joint authors are co-authors, and they have an undivided interest in the copyrighted work. Joint authors, Bernie Taupin and Elton John, one writes the music, one writes the lyrics. So they're joint authors of those musical works. Now they can be separated, if you want to just, reuse the lyrics or something. Under the work made for hire doctrine, and this may apply to you all, the employer is the owner of the copyright for certain works that were created within the employee's scope of employment. So if you hire somebody, pay them to come to work, they are a true employee and their job is to sketch things, you're going to own it. Or let's say their job is to sketch houses. You're going to own that because that's part of their job. Now, if on the weekend they do portrait oil painting, that's not within the scope of their employment. You won't own that. But you own what your employees do within the scope of their employment. And now there are special rules that apply to commissioned works and there to certain limited categories of commissioned works. So there are 9 categories laid out: audiovisual work, compilation, a test, answers to a test, I think a map. There's 9 specific types of works that are laid out. So that's the end of that second segment. Steve, do we have any questions?
Yeah, so I'm interested. Whoop, turn my thing on. There we go. Let's see, a couple. One is someone pointed out that the Oz books by L. Frank Baum are now in the public domain. So can an author take the characters from the original books and create new stories without the approval of the Baum and then sell the new product? What happens when something loses its copyright registration?
All right, once something is in the public domain, you can take and use what you want from it. What I would caution is, you need to make sure it's in the public domain. It's not always clear, and different countries have different terms. So you will definitely want to check. And then secondly, certain characteristics get added later. So those new characteristics protections don't necessarily become in the public domain when the first work does. An example is Steamboat Willie. entered the public domain last year, this year, I guess. You have to be very careful. That doesn't mean Mickey Mouse is in the public domain. You know, the Steamboat Willie version, which is different, they refined it in later terms. And it's also a trademark. So you need to check, well, has it been trademarked? And what other things may have been added that you think of as a fundamental part of the character, but they may have been added by something that was created a little later and has not yet entered the public domain.
Right. Because one should expect that anyone who owns intellectual property will work over time to increase the amount of protection their intellectual property has. And so you just need to be careful.
Right. And so you definitely just need to be careful.
Mhm. And what about a software idea? You know, is it copyrightable, or does one go for a patent on a software prototype or idea?
Okay, an idea is not going to be copyright.
Mhm.
So not for the idea. For the actual software, that's the expression of the idea. All your ones and zeros, you know, the programming, that your software code is the expression of the idea. So that is copyright.
Mhm.
I know you can protect software somehow under patent. I don't know how, maybe somebody else's, but I can just tell you for copyrightability, you can't protect your idea, but you can protect your code.
Mhm. And uh, in a logo, what would someone copyright in a logo, as opposed to getting a trademark on the logo itself?
Okay, well, you would get the trademark to show the source, but if your logo is creative, it's a picture, you know, probably the swoosh isn't going to cut it. I don't know, haven't checked, but I would doubt the swoosh is going to cut it. But if you have, you know, special drawings or designs, things like that, they could be protectable.
Okay. And if I upload something to Facebook, Instagram, do I lose my copyright? What happens?
No, you still have your copyright. You
Mhm.
may be giving them certain rights. I don't want to talk about what you're giving them. They've got, you know, crazy terms of services. You may want to look before you upload what you are what you are doing with your copyright. You know, are you transferring it? I know Facebook used to say you were transferring it. There's a lot of pushback by the music industry. They changed that. But there are, you know, certain licensing rights and things that I think are in the terms of service. So you will want to check. But just by putting something on the internet, you're not giving up your copyright. And that's important on the flip side for everyone to remember. Just because something's on the internet doesn't mean it's not protected by copyright and you can use it.
Mhm.
So it works both ways.
Right. And then several people have asked questions about, is the process automatic, or is it, you have to go through the registration to copyright? It's not automatic.
Well, it's two things. Your copyright protection is granted when something is fixed. So you are protected by copyright when something is fixed. When you register the work, there is an examination, you know, you don't have to register a work. I went through the slides of why you should register the work. One is that you can't bring an action if it's a US work in a federal court to enforce your copyright without a registration. And you cannot get attorney's fees or statutory damages unless the work was registered within 3 months of publication or before the infringement. So there's definite advantages to registering. And there is an examination. It's just mostly to see if the work is copyrightable. So they will look to see, you know, and to see, well, no, this is, you know, this is a work that was created by an AI machine. It's not human authorship, not copyrightable, or this is a useful article, not copyrightable.
Mhm.
It's
Right,
not the
and
same kind of exam that the PTO does.
gotcha. And that segues into several people have asked about things created by AI and are they copyrightable, which you just answered. So you might just want to expand on that a little bit.
Right. It's a really controversial topic. I would refer everyone to the Copyright Office's submitted guidance on this specific issue. PTO has on the, AI inventorship. Copyright Office has on AI authorship. If a work is purely created by AI, not protectable. But at some point, when there's enough human interaction, it does become protectable. The human part becomes protectable, and you disclaim the AI part. And the Copyright Office has given, I believe they said over 200 registrations to works that were, human and AI, where they felt that the human contribution was significant enough to satisfy that modicum of creativity. But, you disclaim the part that was created by the AI. You should really, the best place to do is they have a guidance out there. They also are doing right now they have a notice of inquiry out. They got more than 10,000 notices and reply comments. They are studying the subject. They're issuing reports to Congress.
Thank you. And Ann, you before, but people have asked, is there any maximum to the number of items you can include in one copyright application?
I believe there is, but I'm not sure. And it depends, I think, on the type of work. So I really would refer you to the circulars, because I know that, they worked with photographers, because for a while there was kind of no bulk registration. And they worked with photographers on creating a bulk registration for that. On the other hand, I believe graphic artists are still limited, and so they're still arguing they need a bulk registration, as our news media websites, which, change hourly. How often, how do they register when it, changes every time there's a new story update or something?
Gotcha. And are there any regulations about who can register for the copyright? Is it Steve Roth as an individual, or is it an LLC set up to intellectual property?
I think that's going to depend on the facts of the case. Did Steve Roth, was he the author, or is it Steve Roth because he owns the LLM and his employee did it in the scope of their employment? So again, I would point people to the Copyright Office circulars. They have like circulars on really specific topics, and if it gets really deep, there is a compendium. It's over 1,000 pages, but you can go exactly to the points that you're looking for in the compendium to get the Copyright Office's viewpoint on this.
Okay. And an interesting one, our pieces of clothing, copyrightable.
That is going to depend. Useful articles are not copyrightable. However, there was a Supreme Court case a few years ago with the cheerleader outfit, and they said, well, you can take kind of the design of the cheerleader outfit off of the outfit, and so it could be separately copyrightable. So the cheerleader outfit should be copyrightable. So it all really, it's going to be very fact specific on whether it's separable, whether it's a useful article, things like that. And that I know they have a circular on it, and it's addressed very clearly and specifically in the compendium too.
Okay,
The case is Star Athletica, so you can Google there, or you can word search the compendium for useful articles, fashion, Star Athletica, you'll find it right away.
okay. And then someone asked a good question, which is my editorial comment, and that is these things are all very complicated. Do not be your own attorney ever, right? The old joke is someone who represents themselves as a fool for a client.
Yep.
So if you're going to do anything with patents, trademarks, copyrights with a patent and trademark attorney, and someone asked a question, how do you find a patent and trademark lawyer? Where do you go to look one up? And maybe you could just comment on what process you think people might follow to find a competent patent and trademark lawyer.
We have ethical codes that forbid us for recommending lawyers or things. So
Not that you
maybe
recommend. How would someone
I,
go about it?
I think even anything. So maybe you guys can handle. I don't know if you guys even have a listing of recommended people
No.
or bar associations, things like that. But I don't want to get too much into it. I was always, look at my, local bar association or the bar association where I would want to bring suit.
Right, and I recommend this, basically, talk to your local bar association, your chamber of commerce, other people in your business, find out who they use. It's networking. Most large law firms will have a patent and trademark lawyer, and some patent and trademark lawyers will go out on their own. And then
And I can say, if you're just starting small, there are a lot of services, and in your creator especially, there are a lot of, they're called different things in different cities, but they're volunteer lawyers for the arts. And they often will provide, services pro bono. Law schools have IP clinics that sometimes can provide services.
And then what happens if I've missed the 3-month window that you mentioned before? Is it still worth registering?
Oh yeah, that 3-month window is only basically if you're suing for an infringement that happens like within the first 3 months of your publication, because that 3-month window went to when you can collect statutory damages or attorney's fees, and the second half was within 3 months or before the infringement. So if you register a year out and the infringement occurred at month 9, you're not going to be eligible for statutory damages or attorney's fees. But if the infringement occurs at a year and a half, the work's already registered, so you will be able to collect.
Okay. And then a question, I think it's for when registering works, I think it's works of art. It says there are 2 options for visual artists, published and non-published. Could you clarify what published and non-published means? And if someone posts work on social media, does that mean it's published?
Oh, that's a tough question. Publication is one of the complicated areas. And you can see certain times it might count as publication, certain times it's not. I would definitely go to a lawyer to talk about if you have published your work, especially if you're looking about online, because if you're letting it out there for download, distributions, reproducing copies, things like that, that's publication. A pure performance wouldn't be a publication. But sometimes a posting of it online, maybe. So I would say this gets into the it's very fact specific.
Okay. And what about if I'm publishing ebooks on something like Amazon? Should I apply for a copyright then?
Yes, I would say you should always apply for a copyright, unless you don't care if you're infringed. If you don't care if somebody is going to take your book, repackage it, and sell it themselves, then you don't need to register. But if you care and you don't want them doing that, you want to register your work.
Okay. And we should probably move forward with the next section.
Okay, this next section is about copyright infringement and enforcement. So, what is copyright infringement? How come it's on a continue page? I don't know. So, infringement is a violation of any of the exclusive rights of copyright. You remember I talked about that bundle of rights at the very beginning. What does copyright give you? So, it gives you that bundle of rights. If somebody violates any one of those rights, that's a copyright infringement. So what do you have to prove in a copyright infringement case? Validity and ownership of a copyright, as well as if it's a US work, you have to show it, you have to have a US registration, and violation by the alleged infringer of one of those bundle of rights. There are a few different kinds of liability for copyright infringement. There's direct liability. The person you're suing committed the infringement. Then there's secondary liability. And some people say there's two kinds, some people say there's three kinds. But it's all the same, because contributory liability implies knowledge. The defendant knows or has reason to know that they're infringing. So that's one spoke. The other spoke is they materially contribute to the infringing conduct, or they induce the infringing conduct. Some people consider inducement a part of contributory liability. Some people have it as a third type of secondary liability. Just know it's there. You can't induce someone to infringe. Grokster did that. Vicarious liability. This does not require knowledge. This just has the right and ability to control the infringing activities and a direct financial interest in such activities. So now there are certain limitations and exceptions to copyright, which do let people use the copyrighted works without permission. First one I'll talk about is the first sale doctrine. This is for non-digital uses. So if you buy a physical book, a physical painting, a physical LP, you're allowed to sell that. That's called the first sale doctrine. Our law also has special exceptions for libraries, archives, and teachings as to what they can copy and perform. There are certain statutory licenses in our law, certain television and radio exceptions in the law. There's a provision for reproduction for those with disabilities and for making something available in a format for people with visual impairments. You can make a single software copy for archival purposes. I just want to tell you that, again, if you want to use something, contact a lawyer, because the exceptions are very, very specific. And a lot of them have like 4 different, components to qualify for the exceptions. I'll give you an example. Like we run educational programs at the PTO. We bring in foreign government officials and train them. And I was going to show, I want to show a movie to go through the fair use parts, like when the movie uses copyrighted works, and to explain the US doctrine of fair use, which is my next slide. But looking at the exceptions, I saw we did not fit into an exception. Now, if I were a nonprofit accredited educational institution using it in teaching activities, I think I would have. But we were the US government. We weren't a nonprofit accredited educational institution. So you really need to look so I had to get permission. So you really need to look very specifically. The other thing I want to say is, don't be scared to ask for permission. There are a lot of times people will give you permission free or for a reasonable cost. The fact that you ask for permission, it often doesn't take that long, and it can relieve a lot of headaches. Okay, so now we'll talk about the fair use exception. And the fair use exception allows the public to make reasonable uses of copyrighted material under particular circumstances without needing authorization. So this is in general for use purposes such as comment or criticism, news reporting, teaching, scholarship, research. And there's a 4-factor balancing test. This is set forth in the law. Purpose and character of the use, including whether the use is commercial nature, whether it's for nonprofit educational purposes, whether the use was transformative, the nature of the copyrighted work. Basically, is it a factual work or is it an expressive, creative work? The more expressive and creative it is, the more likely this weighs in the defendant's favor and the author's favor. They look at the amount and substantiality of the portion used in relation to the copyrighted work as a whole. The more you use, the more likely it's not going to be fair use. And it's not just quantity. They also look at the qualitative heart of the work. There was a case where they took, the heart of the work, and even if it wasn't quantitatively so much, qualitatively it was important. And then they also looked at the effect of the use upon the potential market for or value of the copyrighted work. So it's not just the substitutional effect, it's the effect on the entire market or potential market. So now I'll talk a little bit about the remedies you can get. Actual damages, that's the only thing that's going to be available to you if you haven't registered before the infringement. Statutory damages, injunctions, including temporary and permanent injunctions, seizing the infringing copies, destroying the forfeited infringing copies and the equipment that made the infringing copies, and attorney's fees and costs. And again, the attorney's fees would only be eligible if you registered before the infringement occurred. Now, for a lot of small business purposes, you got a major benefit in 2020 when the CASE Act was passed. And this basically set up a copyright small claims court within the Copyright Office. It's a 3-member administrative tribunal located within the Copyright Office. It considers claims, but the cap on the award, $30,000. And that's not all, that's not each claim, that's the total claim. I believe it's $15,000 for each claim, but I'm not positive. They can also hear claims for a declaration of non-infringement. And a CCV decision is reviewable in both the US Copyright Office and the US federal courts. So why would this be advantageous to you? I think if any of you have ever been involved in federal litigation, you understand the costs involved in federal litigation. I'm sorry, if I said legislation, I meant litigation. So the advantages of a CCB proceeding is they're very streamlined, limited discovery, and most of the proceedings are handled completely electronically. You don't have to come to the office in DC. You don't need a lawyer. It's much less expensive than federal court lawsuits. The total monetary damage is capped at $30,000. So it's a voluntary proceeding where parties can opt out. But if you're the defendant in one of these cases and you opt out, they can then sue you in regular court, and there's no $30,000 cap on the damages. So, you could stay in this fast track limited discovery procedure, knowing that there's going to be, if you're found guilty, there's a cap on the damages. It does have safeguards against abusive practices. So that's the end of that section. Steve, do I have any questions?
Yes, hi. Am I back? No, I'm not back.
Yes, but we can't see you.
Oh, no. There we go.
Now we see you. Okay.
So,
And all I can say is you can't ask me if something is fair use, because it's a balancing of the 4 factors, and it's very complex and fact specific. And even with all the facts, courts reach different decisions. I'm just going to say contact a lawyer to decide if something is fair use.
Yeah. I mean, I was going to say, for a lot of the questions, they're very, very, very specific. And there's no way they can be answered, I think, in a truly general sense. Because the lawyer would have to understand the specific use and what you were doing. But a couple of them.
And even then with fair use, I was reading a decision today, and a circuit court was reversing a district court. They had the same facts. The Supreme Court last year came down with Warhol, reversing the Second Circuit. No, upholding the Second Circuit, which reversed the district court. So even with the same facts, courts reach different decisions.
Mhm.
So it's
Right. And
Yeah.
so someone asked a question that's kind of interesting in a general way. That is, if I'm in the bar industry, how does copyright affect what I do? Of music, live and recorded, what are my
Right.
obligations when I replay something?
Okay. I'm taking it that you own a bar restaurant. And first of all, okay. So if you are performing any kind of copyrighted work in your bar, generally you need permission, or you have to fit into one of the exceptions. So it depends on what you are performing, how you are performing. So generally, if you're performing music, live records by Spotify, however you're doing it. Well, Spotify is a special commercial license too, but however you're doing it, you're going to need a license from the music rights PROs, performance right owners, ASCAP, BMI, CSAC. I'm not sure if GMR does domestic bar licenses. Now, if you're just playing the radio, the regular commercial radio in your bar, or just a regular TV in the bar, not a paid TV boxing match that you're going to get into trouble or things like that, but just your regular TV station. You need to look, because there's an exception, and that exception though depends on how many square feet you have and things like that. But then again, you need to be careful when you look because it only applies to like a radio, like a broadcast.
Very good. And then kind of an interesting thing, because I think it might affect a bunch of, is someone is looking to sell vintage Chanel jewelry on a website, and use the licensed Chanel name in the description. How do you do that without running afoul of the use of the word Chanel, which I'm sure is copyright marked and protected, can be protected?
If that would be Chanel, I believe that would be a trademark issue. And it would require whatever trademark licensing, I believe, would be required. It's not using the word Chanel would be a trademark issue.
Right. The key would be to sort of properly present the word way the trademark calls, because you're not stealing the trademark. It's just a Chanel bag. It's the description of the bag.
Yeah, I don't want to give trademark advice. I would just make sure whatever you're doing, you're not saying something Chanel when it's not.
And then one has how do you check on the status of your copyright? You submitted a form, you submitted the application, and the process, like if I want to check on where it is, and does an incomplete copyright application have an expiration date?
I don't know that. I would look on the Copyright Office's website. I don't believe that applications hang out there incomplete. They're going to be accepted or rejected, and because you need that before you go to court.
Okay, very good. Do the next section.
Oh, okay.
Yeah.
So now I'm going to talk briefly about protection of copyright in the digital age. See, this used to be the new part, but the digital age started in the 90s, so it's not really so new anymore. So I guess in 10 years, we're going to say protection of copyright in the AI age, but we're not there yet. So the WIPO treaties were negotiated in 1996 to bring the copyright law into the new millennium and to deal with digital works. The U.S. implemented there were two internet treaties, WCT and WPPT, and the U.S. implemented them via the DMCA in 1998. So it's now 25 years old. So these treaties came up with three important new rights. First is the right of making available to the public. And what that means is interactivity. This wasn't really very possible before digital technologies. It's the Spotify's, it's the Netflix, it's I can watch what I want when I want from wherever I am, not ABC is broadcasting Grey's Anatomy at 9 o'clock, so the only thing I can watch is Grey's Anatomy. So the new making available right is, I call this making available interactive kind of pull technology. I'm pulling what I want to watch. The old technology, broadcast technology, cable technology, was push technology. I had to watch what they were pushing out. So they created a new right for these pull technologies, for these interactive uses. And nowadays, frankly, I've cut the cord. All I have are these new, I only pull. I don't watch anything that's pushed to me. So this is really taken over now. I think most of us just watch what is considered making available. It included legal protection of technological protection measures to protect copyrighted works. So we call them TPMs. So if the owner of a copyrighted work uses a TPM, we protect that right. And then we also have legal protection for rights management information. And that is information that's attached to a work that has rights information on it. So it might say, you know, who the author is, who the owner is, what kind of licensing terms you can use. You know, you can't change that. I can't go in and say, oh, it's not Taylor Swift. I'm going to replace that RMI with Ann Chadovitz, and so I'm going to get paid instead of Taylor Swift. You know, that would be breaking the law. For this, that would be violating the rights management information prompt. So the Digital Millennium Copyright Act, it prohibited circumvention of TPMs that controlled your access to the works. It bans trafficking in circumvention devices. So you can't sell a device that enables somebody to circumvent the TPMs. It prevents tampering with RMI. Again, I can't say that Ann's the author, not Taylor Swift. Importantly, the violation of TPM and RMI, it's not an act of copyright infringement. It's a separate independent offense. And it also, our act has limited liability remedies for infringement for the internet service providers that meet certain criteria. And I'm going to talk about one of those criteria in a minute. Important thing to remember, 1998, when this law took effect, it was passed in, I think, 1996. I believe 1998 was the year that Google first incorporated. These internet service providers were babies. They were nascent. They were just starting. Congress didn't want them to have, you know, a lot of liability and kill the new, you know, the internet before it had a chance to develop or start. So the balance was, hey, they help, you know, we give them some carrots and they have to help stop infringements, but then we're going to give them this liability limitation. And it's just really interesting because back in those times, you know, the content owners, the big bad record labels, like dwarfed the ISPs. You know, the ISPs will just like teeny. And now, of course, you know, the balance worked. Some might say to an extreme because now the ISPs are, you know, the biggest companies in the world. So one of the criteria that they have to meet to get this liability limitation is notice and takedown. So they will have, you know, limited liability when they meet certain criteria, and it's very, very complicated. There's 4 kinds of ISPs. Each one has separate criteria. So in the law, so it's very complicated. But one of the things that some of them have to do is once they receive proper notice alleging infringement, they have to expeditiously take the material down and notify the user. The user can then respond by saying, hey, wait, no infringement here. I own this, in which case the ISP has to put it back up unless the rights holder notifies them that they filed a copyright infringement suit. So this is kind of the notice and takedown system. Interesting, you know, we're now 25 years down the line, about 20 years down the line, the Copyright Office issued a big report about how well this section 512 of the law is working. As you can imagine, the ISPs like it, the creators and the rights owners don't feel it's worked. They feel it's work, they feel that they have to play what they call whack-a-mole. They have to monitor the internet. If you're an independent creator, some of them say, I don't have time to create. I can either create or monitor the internet to try and send these takedown notices. And as soon as they take it down, it pops back up within like a minute. So that's notice and takedown. And that's the end of the presentation. I now have some copyright like Q's and A's and myths that I'll talk about and the resources. But I don't know, do we have questions now or should I finish these myths first?
Well, there's one person wanted to ask for a clarification on something that was the use was transformative. What does that mean? Could you elaborate a little bit?
It's a good question, and courts are now interpreting that kind of new and fresh over after Warhol. Transformative goes to how the new work, are they adding something new and different to the old work? But that's kind of what, remember I talked about the 5 rights, the derivative rights work are. And so before Warhol, it seemed to be going, the transformativeness seemed to be getting broader and broader, and a lot of rights holders were concerned that it was slowly impending or reaching into their derivative right work. And the Supreme Court kind of pushed back a little bit in Warhol and, said you also have to look at the use. And here in Warhol, it was a Warhol made a photographer, Lynn Goldsmith, took a picture of Prince when he was young and starting. And she's a famous, rock photographer, and she sat him and she did the makeup and the lighting. And then she at one point licensed Vanity Fair to do a cover and to use her photograph as the reference. And then Vanity Fair they licensed the photograph from her and they used it for a reference to send to Andy Warhol, and he created the Prince cover. Fine. Unbeknownst to anybody, he created 15 other in his Prince version. And then when Prince died, Vanity Fair, rather than licensing from from Lynn Goldsmith, used one of the other Warhol prints. And the court said, well, it's, the purpose is the same. It's to be on the cover of the magazine. Or, this is really infringing to be a reference point or to be on the cover of the magazine, because a lot of magazines, tribute magazines had photographs. Vanity Fair used the Warhol print, but they didn't license it again from Goldsmith. They did license it again from the Warhol Foundation. And it was interesting because the case was, specifically related, and they tied it to this use. They weren't going to whether, the Warhol creations for a museum were fair use. They were saying you have to look at it use specific. And in this, use, it wasn't transformative and was not fair use.
Great. And then someone that might be interesting for you, not be answerable, but you have YouTube sites where people are with lots of subscribers, where they read children's books online. And how do they do that? How do you read a children's book online to your YouTubers? Are they, violating the creators of the books? Right.
Oh, they sure would be, depending, Winnie the Pooh's now in the public domain, so you can read, I believe, yes, you can read Winnie the Pooh. I think it's Now, don't quote me, double check if you're gonna use Winnie the Pooh. I'm pretty sure it's in the public domain, as of like 2 years ago. But, if the work is still under copyright, they should have permission from the authors or the copyright owners, and they may. Because, for example, you see on YouTube, a lot of music is posted, or a lot of videos that use music or sound recordings are posted. And that's because, unbeknownst to like us who are just using YouTube has entered licensing agreements with the owners of the musical works and the sound recordings to let those be used on their services. And if not, sometimes they'll strip the sound out. So you'll see it without the sound. But otherwise, oftentimes we don't even see they have entered a license.
And someone asked a question about something I've never heard of before, but it's called poor man's copyright.
Yeah, that's going to come up in my Q&A in a second.
We will wait for that. You'll do that. Don't worry about that. And I read that.
Pardon?
Yeah, why don't you go?
Okay. So here are some common copyright myths, and one of them is the poor man's copyright. First is, and we've talked about a lot of these. So the first is you have to register your work to own a copyright. As we said, that's not true. You own your work as soon as it's fixed. To sue, you have to register your work. To sue, if it's a U.S. work, foreign people can come to the U.S. and sue on their foreign works without registering. And that's because under international treaty obligations, that's required. And another myth, you have to put a copyright notice on your work to protect it. Nope, you don't need it. It's going to be protected anyway. Always good to put it on because you're giving somebody notice and you're telling them how to contact you. So get permission, get a license. We talked about this one. If it's on the internet, it's in the public domain and free to use. Nope. Just because it's on the internet, it's not in the public domain. It's not free to use. Things on the internet are protected by most things, not everything, but most things are protected. So make sure to get a license if you're using something. Copyright protects an author's hard work. No, it doesn't protect your hard work. It protects your creativity. So you can spend hours putting together a phone book, and it doesn't matter. You can spend a minute dumping paint on a piece of paper if you're Jackson Pollock and you've got protection. Okay, here's myth 5 is poor man's copyright. If I mail a copy of the work to myself through the postal service, the copyright is registered. No, it's not. You have to go through the Copyright Office registration process if you want to register. Okay, myth 6, which goes to what you were saying before with the 30%. The myth 6 is 10%. Nope, it's not at all about that. If you want, you can use a work without permission if it fits into one of the exceptions and limitations, and there are no numerical amounts. And, the heart of the work is going to be different from, a less important part, whether it's commercial is going to be less, commercial, non-commercial, all these things are considered. I can use protected material without permission if I strictly use it for educational or non-commercial purposes and give the author credit. Nope, not permitted. I told you my story. Government, nonprofit, trying to use it for educational purposes, didn't fit into the exception, had to get a license. So there are exceptions for educational and non-commercial purposes, but you have to make sure you fit into those exceptions. If the copyright holder didn't register the copyright, I can't be sued. Not true, because they could be foreign copyright holder doesn't have to register the work, or as I said before, they can then register it after you use it. They can register it and sue you. They just won't be able to get statutory damages, but they'll be able to get actual damages. So as long as they register it before they sue you, they're okay there. And here are, now we have 2 pages of resources. I see the top one talks about checking out Circular 1, Copyright Basics. I think all the circulars are really important and helpful because they have answers to all kinds of questions. So I would look at them all, and here's some more. Resources. I'm gonna go back to, we have the Copyright Office also now has a fair use index that's searchable. It has all that, you know, where they keep track of all the fair use decisions.
Okay. One other, or a couple of other questions I
Okay.
have. Are there any fundamental differences in terms of copyrights for nonprofits versus for-profits?
Not really. There are some differences in, you know, certain of the exceptions might apply only to nonprofits, or it's considered, you know, in a fair use analogy, not determinative, but considered. So it plays a role. If they're asking about copyrightability, it does not.
Okay. I didn't think there was any, but I didn't know for sure.
Yeah, not when we're looking at copyrightability.
And then would you comment briefly on kind of the US versus other countries, interactions? Someone does something in France, you want to do the same thing in the United States, they're copywritten in France. What's the reciprocity between these things?
Right. Okay. I like to say, and it's a little complicated, that copyright protection is global, but copyright legislation is local. So if your work is protected by copyright in any country that is signed, the Berne Convention or the WTO, all the other countries that have signed have to provide you with national treatment. So they have to respect your copyright and provide the same protections to you that they would provide to one of their residents. But that means is what they would provide to one of their residents. So let's say you create a work in the US and it's infringed in France, right? So you go and you sue in France. And then France is going to have to treat you like with the they're going to have to acknowledge your copyright and treat you like as if you were a French citizen, or somebody's protected by the French law, which means that the French law will apply. Now in the US, and it gets more and more complicated as things are, created in one company, maybe infringed in another company, but then downloaded in another country. And what happens, like in the US law, is we look to if a foreign creator was suing in the US, we look to the foreign law about who owns the copyright. And then we look to the US, it was infringed here, US law on infringement would apply. So there was a lawsuit, I believe it was Southern District of New York, where some Russian newspaper owners sued because there was somebody who was aggregating all their columns and putting it on the internet for people to download, infringing. So the Russian news agencies sued in the US for infringement. But we have to look to Russian law to see who owns the copyright. And under Russian law, the authors owns the copyright, not the news agencies, unlike US law. So because of that, they didn't have standing to bring the case because they weren't copyright owners under the Russian law.
Yeah.
But, you know, nor had they been the copyright owners under the Russian law, once they finished that part of the case, they would then look to US law for the infringement and things like that.
Very good. And if someone wanted to license their artwork, you know, should they register it before they put it on social media? What would your thoughts be?
I would.
Mhm.
I would think, I think registration is helpful. And you know, because as soon as you put it on social media, it's out there for people to infringe. For, you know, there's a lot of people who haven't done this copyright course and think, oh, it's on the internet, it's public domain, I can use it. And we know that's not true. But you put your work on the internet and people might use it.
Very good. And with that, we should probably turn it back over to Eliza. Let her do her.
Thank you all.
And you're fantastic. Thank you very much.
Yeah, thank you so much, Anne. That was a wonderful presentation. And thank you, Steve, for helping out as well. I have launched the course evaluation poll for all of the attendees. So if everyone could please take a moment to fill it out, that would be great. Your feedback helps us make sure that our webinars are relevant to you, and it lets us know if you want us to do something like this in the future. So there are 6 questions that are mandatory and 1 optional question for 7 questions in total. It takes about less than a minute to fill out, so I am just going to let that continue to run while folks are submitting their answers. Sunny wants to know if they can contact you with follow-up questions, or who should they contact?
Well, they can contact me, but again, I'm not allowed to give legal advice. But they can, you know, they can feel free to contact me.
Okay, sounds good. Just a few quick reminders for everyone while you are filling out the poll. I will be sending out a copy of Anne's presentation via email in a PDF format, so please keep an eye out for that. And today's recording will also be sent to you as well so that you can review everything that was talked about. I'll also include in my follow-up email some additional links from the Copyright Office and the USPTO so that you guys have those resources available. Awesome. Got about 1 more minute here, and so I'm just going to let the poll run for a little while longer. Thank you again to everyone for joining us this morning. Thank you to all of you who have filled out the course evaluation poll. Thank you to Anne and Ken for being here. And yeah, we hope you have a great rest of your day. And we hope to see you in a future webinar.
Thank you.